Hello and welcome to FFRF's Ask an Atheist. I'm Liz Cavell, Deputy Legal Director at the Freedom from Religion Foundation. I am joined by our Rapid Legal Counsel, Chris Line, again. Hi, Chris. This week we are back looking at the major Supreme Court decisions that have had implications for separation of church and state and secularism. If you missed part one of our coverage, you can check that out on our YouTube channel.
Yeah, today we'll be talking about three cases: U.S. v. Skrmetti, which upholds a ban on gender-affirming care for minors; Medina v. Planned Parenthood, which blocks patients from challenging religiously motivated provider bans; and Mahmoud v. Taylor, which gives religious parents new veto powers over public school curriculum. So let's just start with U.S. v. Skrmetti. The Supreme Court ruled 6-3 that Tennessee can prohibit gender-affirming care for minors. The state argued that it wasn't discriminating based on sex because technically it banned this care for all minors seeking treatment for gender dysphoria, regardless of sex or gender.
That's clever.
Yeah, so as people are probably aware, these bans aren't actually based on medical science. They're based on religiously motivated fear and stigma. The care being banned is supported by every major medical organization, the AMA, American Academy of Pediatrics, the APA, all of them. It's life-saving, evidence-based care.
Right.
Full stop.
So, a couple of things on this. One, we get often why we cover cases like this, why we weigh in on the anti-trans wave of legislation being put out by state governments and the federal administration. And it's important, I think, to just acknowledge that these bans, like you said, are not evidence-based, and the courts weighing in on them in this way to kind of come down with or really like shoehorn a religiously, socially conservative value judgment on these issues is religiously motivated. We know it's Christian nationalist legal organizations that are pushing these bills through state houses, that are helping defend these lawsuits and or taking lawsuits to make sure that gender affirming care is not available, and to sort of manufacture this sort of controversy or lack of consensus in the medical community around the safety and efficacy of gender affirming care, which at the minor level, age level, can often just include, gender affirming counseling and puberty blocking treatments and hormone therapies and things that are otherwise available to minors that are facing all kinds of other medical issues like precocious puberty and growth issues. The only purpose for which it's being prohibited is gender dysphoria, which the court, again, sort of just took a sledgehammer to equal protection law analysis and also just logic to say that, well, that law actually applies equally on the basis of sex, because boys and girls can't get gender-affirming care for gender dysphoria, right? Just like ignoring the fact that the only minors with gender dysphoria are trans kids. So to sort of buy the state's argument that this is not a sex-based classification, in other words, it doesn't discriminate on the basis of sex, is a fiction and a lie, and it just allows the court to totally sidestep any equal protection analysis or give any equal protection to the kids and the families that are challenging these laws.
Yeah, I mean, and this just falls in line with what we've seen, these attacks on sort of bodily autonomy, on individual rights, or any right that sort of interferes with sort of the narrow Christian nationalist view of like what someone's life should be like, what type of person should you be, how should you live your life. We're seeing the court, in its rulings implement that and say, we're going to allow you to make laws that align with the sort of Christian nationalist view of who you should be, even if we have to, take away some rights to your own body in order to do that.
And again, like the Tennessee law that was being challenged in this case was, sex classification was all over the law, right? Like it the purpose of the law written into the legislation itself was to, I'm paraphrasing, but something like to make sure that young people appreciate their birth sex and don't like seek to denigrate their birth sex, right? It's all about accepting a binary sex and accepting and, not denigrating your birth sex. And so the idea that like banning care for that purpose for only trans kids isn't classifying kids based on sex is absurd.
Yeah, I mean, so basically like if you were born male and you want to reaffirm that through gender-affirming care, that would be fine. If you're a male who wants
need hormone therapy, if you have low testosterone, that's fine. But if you're a born male minor who is seeking the same therapy but for transition care, gender-affirming care, that is prohibited by the law. But that's not a classification based on sex because it applies to girls in that position as well. Right. So Chris said it was a 6-3 decision, split along ideological lines, as they say. Justice Sonia Sotomayor didn't hold back in her dissent. She accused the majority of retreating from all meaningful judicial review and abandoning trans children and their families to political whims. Because of course, this came up in the oral arguments, but the majority pretty much just satisfied itself by saying, these questions should be decided by, the political process.
Right, which is not typically the way you want to
protect minority rights.
Yeah, exactly. As our co-president Annie Laurie Gaylor put it, the Supreme Court needs to quit practicing medicine without a license. So, as you said, these decisions are not about protecting children; they're about enforcing a narrow religious vision of gender.
Yep. So, along the same vein of the court taking it upon itself to tell people how to exercise their bodily autonomy, we had Medina versus Planned Parenthood. This was a case we were watching somewhat on the abortion issue. The court again ruled 6-3. And this ruling was about whether or not Medicaid patients can sue under the Medicaid Act when a state kicks Planned Parenthood off the list of approved providers, even if for purely ideological / religious, anti-abortion reasons.
Yeah, I mean, in this case, South Carolina actually admitted that Planned Parenthood was qualified, but because it provides abortion care, the state removed them anyway, a move which has been pushed by the Christian Nationalist Alliance Defending Freedom, who actually represented the state in this case. Right.
This is an anti-abortion tactic to get Planned Parenthood off of the list of approved providers under the Medicaid Act, which is a statutory a law that sets up how Medicaid is administered and what rights patients have under or who are on Medicaid. And so, by taking technically this case was only about whether or not patients had a right to sue under the Medicaid Act about Planned Parenthood being removed as a provider, basically takes away completely the rights and the autonomy of patients to choose their provider, and of course creates massive holes in care, because Planned Parenthood, as many of us know, is a major provider of not just abortion care, but other women's health care.
Yeah, I mean, that's the thing to highlight here, is it's not even like they're like, oh, well, you can't use Medicaid to get an abortion through Planned Parenthood. Right. It is that you can't do anything, no matter what. Any sort of service provided by Planned Parenthood can no longer
They're not a doctor in your network. You can't go there if you have Medicaid.
Right.
Already, Medicaid doesn't pay for abortion care. So we're talking about going well beyond that to make sure that, Planned Parenthood is as harmed as possible and that women's health care is as balkanized as possible. And states can take away health care from women to the nth degree. And those patients, women on Medicaid, have no recourse. So again, a 6-3 decision with Justice Jackson, KBJ, writing a really powerful dissent. She warned rightly that this decision will cause tangible harm to real people, stripping patients of their only real enforcement mechanism and also their right to choose who treats them under Medicaid.
Right. Same thing with everything we've been talking about. Attacks on bodily autonomy and your right to take care of yourself and to make medical decisions, your own medical decisions, being undercut by the Supreme Court in order to push sort of the Christian nationalist view of like what you should be allowed to do or what you're allowed to support. Like,
right.
Like not even that you can't get an abortion, that
but
you
Planned
can't.
Parenthood is evil, so you can't go there for treatment if you're on Medicaid.
Right, and just obviously the underlying theory behind that then could be applied to any different organization. Like they could do this for, other groups that there's an ideological misalignment. They say, well, we're not going to provide any, federal funding anymore for that. And immediately after this came out, Tony Perkins, Family Research Council,
oh boy.
Of course, came out and said that now that it's ruled, every pro-life state should follow suit and
right.
end it all across the country, and that Congress in the new bill, which also trying to defund Planned Parenthood across the nation. So it's all clearly just an attack on a provider that does provide abortions, but also a ton of other care. It's just Christian nationalism being supported by the court in this decision. Our co-president, Annie Laurie, cut right to the core of this. She said, we're watching the demolition of the separation of church and state in real time. These rulings are part of this broader movement to impose Christian nationalist beliefs on everyone, especially women and marginalized patients.
Right. Again, like Dobbs overturning Roe versus Wade being just the beginning of the project, and the whole idea of, well, we'll let the states decide on abortion law on their own terms. Of course, we know that's bull, because we hear, Tony Perkins and all his cohort pushing for these same restrictions to be pursued at the federal level. But also, it's not enough to just restrict abortion and how abortions are administered state by state. Like, Christian nationalists want to make it so that they control what kind of care women can get from who and how that care is ideologically oriented, right? It's not enough to say abortions are restricted in this way. It's, you can't go to Planned Parenthood because we don't like their attitude towards abortion. Well, the third decision is Mahmoud versus Taylor. We were watching this one. It came down absolutely last. This is the case involving the public school district in Maryland that had approved some LGBTQ inclusive books in their English language arts curriculum approval list, and opt-outs for parents became unworkable. They sued. So this is the court saying that religious parents who don't want their child exposed to LGBTQ plus characters in storybooks that are approved by public schools have a right to be notified and a right to opt out. And that's what these parents were asking for in their lawsuit. Lower courts had rightly denied that request, saying that public schools are not required to tailor curriculum to individual religious beliefs. And again, we probably, if you've read any of our coverage on the case, have covered this somewhat, but the case below, I just want to point out in all these cases, this is the Supreme Court sort of lurching to reach this result. The court did not have to go here. All the lower courts, the lower appellate court agreed that this record was not really developed to the point where you would make a sweeping constitutional ruling that the Maryland public school in this case violated the free exercise rights of these parents, because there was really no evidence or factual findings below about how or whether these books were actually being used in the classroom, what had been taught, how any individual student was or wasn't exposed or taught or talked with teachers or staff about any of these materials. But yet the Supreme Court is impatient to reach this result, which is that, this school even just approving these books for use is violating the religious rights of the most extreme conservative religious parents in the district.
Right. Alito, writing for the court,
always a good
said
sign,
the books were inculcating values that conflicted with the parents' religion, and that not allowing them to opt out was a violation of their free exercise rights. Obviously, that logic's terrifying.
Right.
gives religious parents veto power over what students can learn. Clarence Thomas even suggested that any LGBTQ inclusive material in school could be considered hostile to religion.
Give me a break. Well, an important thing about the ruling that Chris is getting at is that there's no principled boundary in this ruling that would stop it from applying to any other subjects or, approved curricular materials that conflict with any other religiously motivated ideals or values. And so this puts an unbelievable burden on public schools to have to, anticipate or respond or just have this sprawling system of opt-out accommodations for anything that could be offensive to the most extremely religious viewpoints in its district.
Yeah.
Sotomayor brought this up in dissent, but the most obvious being evolution, teaching of evolution, or teaching about women scientists, Marie Curie she brought up, or teaching about vaccine history and efficacy. This is a unbelievable burden and just stupid slippery slope to open up in public schools. And it's this anti-secular ideology that the court is reflecting, which is that secular values are hostile to my religiously held values that are either closed-minded or bigoted or anti-LGBTQ, and anything that is just even remotely inclusive, because the materials at issue in Mahmoud are children's books that are not they're not centered around LGBTQ relationships. Right. They just show the existence of LGBTQ people.
Yeah, I don't know how I would handle that if I were a school based on this rule. I mean, obviously the majority in writing thinks that they're just picturing Christianity. They're
Yes.
Okay, well, things that offend Christians, they'll be whatever, but they're not thinking about the other religions or even niche small religions or any weird. I don't know. So a school
Right.
district, someone says, I would like to opt my kid out of the math curriculum. We don't believe in math. Obviously your gut reaction would be, that's insane. Tell the teacher too bad, or tell the parent too bad, your kid needs to learn math. We're a school. But I don't see any reason under this why they wouldn't have to be afraid that there could be a lawsuit about their free exercise rights of that parent because they object to math. I mean, like you said, there's no real limitations that make clear something like that wouldn't be okay.
Right.
Or obviously, noted more, let's say a story has a single mom in it or something. I mean, just the most mundane things that you'd be because that's what we're seeing. These book ban topics and things are not they say that this is pornography in schools,
Right.
but it's you said, it's nothing. It is
Right.
things you wouldn't, people reading it, you wouldn't even think about. You'd read your kid's book and you'd be you wouldn't even know there's anything wrong with it till you saw the headlines about
or
Moms
whatever.
for Liberty.
Or this is a book about, it's for teenagers, it's for high schoolers, and it has premarital sex in it. It's oh, that's on the Moms for Liberty list, so our kids can't read, books that have been in the canon of young adult literature, American literature, for decades because it offends the religious sensibilities of the most conservative parents. And so, it's just a further march down this road for this current Supreme Court of the free exercise and religious rights trump every other consideration in civil life that there is, including giving a holistic education to kids in public schools that will allow them to exist in a pluralistic civil society when they leave school. This is not, meanwhile, it's okay to inculcate actual Christian religious ideas in public schools, but not these secular ideas that offend people's conservative religious values. It's just this totally warped inversion of what the First Amendment was meant to do, and what the Free Exercise Clause was meant to protect against.
Yeah, no, exactly that. I mean, we've seen in cases and we've seen elsewhere where this the ruling that like, oh, the Bible is something kids should learn about. Like we can't indoctrinate them in schools, but like that's very common of like, oh, kids should learn about what the Bible is and stuff like that.
The Bible exists, Christianity exists, Christian exists.
Right, and we've seen that pushback when we try to stop the Bible being taught as religion in schools, but then here, any mention of LGBTQ people is just unacceptable. Like you can't.
If it's not negative, like this is literally in Alito's opinion, and if you listen to oral arguments or you read a little bit about the books that we know are at issue in this case, it's really that they include like gay married people with no negative treatment. Right. It's like, it's not centered on them, and it's not like, and because the book is like, the one book we might have talked about this on this show, but if not, it's about Uncle Bobby's wedding. And it's like a niece whose uncle is getting married, and she's really upset about it. And her parents and stuff are talking to her about how like it's okay. And so Alito at oral arguments kind of brought it up as though to imply that like little Chloe or whatever was like a homophobe. Like she didn't want her uncle to get married to another man. Really, she's worried that like she'll lose his attention because they have a close relationship. The book is about like getting her through this difficult transition, and she's going to lose attention from a family member, and it ends up it's a happy occasion, and they talk to her about it. The fact that that book featured a gay wedding and it was like a positive story is enough to trigger this like free exercise clause violation that triggers this high level of scrutiny that triggers Alito into this sweeping constitutional opinion. So like that's what we're talking about here. It's just materials that acknowledge the existence of LGBTQ people and relationships, and in any way like celebrates or even just like positively treats that existence. That is what we're talking about. Those are the types of materials that are violating people's religious rights by not being able to opt out of any exposure to those ideas. It's crazy.
Yeah, but it's important to note and to really focus on like the damage that this is going to cause, because there's a way, and obviously it's going to be painted this way of like, oh, well, who cares if a few parents opt their kids out of reading this book or being involved in that. But the reality is that's not how school curriculums work. And so instead of going, oh, well, for this one, 10 kids are going to have to leave, and for this one, that, and like all of that, they're going to just take them out of the curriculum. So it ends up being a veto. And we know this is going to happen because we know, I mean, we've seen just with the book ban stuff, how far like Moms for Liberty has gone with this stuff. So what's going to happen is any school, the second it comes out public that this school has this book in the classroom or has some potentially objectionable thing from a Christian point of view in the classroom, Moms for Liberty and those activists are going to alert it, get outraged to the point where like half the classroom is not going to be able to be there, and it's going to be removed.
And schools can't be expected to deal with those types of burdens. And so it effectively imposes like a heckler's veto over all this category of material, which is like inclusivity, visibility and inclusivity material for teaching our kids about like acceptance. And that's the point of it. And I didn't coin this, so credit is to Ian Millhiser at Vox who writes about it in this way, but it's so true. It's basically imposing a don't say gay regime on all public schools, like a la the Florida style, which is it creates these burdens on schools that are so onerous and give so much power to the most conservative minority religious parents that schools ultimately are just going to err on the side of not teaching about, not featuring, not highlighting these subjects.
Yeah, I mean, and then like we said, it's going to be interesting to see how it plays out with core issue. Evolution is a core scientific concept, but what happens when none of the kids can come learn about evolution? Obviously inclusiveness is important too, but like there's other ways to do inclusion that they can kind of dance around that, but like things like core curriculum science, things involving science and things that like are just true facts of the world that kids need to learn to build a basis to learn other things and to develop and to move along in their careers and to learn more in schools. What happens when those get banned or when they can't teach those? The school can't just stop teaching science. It's going to be chaos for schools to try to navigate this and how they can make this work, fulfill their duty to teach students and meet this new burden imposed by the Supreme Court.
And again, it's all part of a broader project to both ever expand the free exercise right and what it means to the point where it swallows up all other, neutral civil laws, and to undermine public schools to the point of privatization, where there's no difference essentially between being in a private school and being in a public school, because the most extreme conservative religious views rule the day in public schools, and all of the public money that supports our public schools freely flows to private schools. So it's all part of a broader Christian nationalist project, which includes undermining public schools and expanding religious rights ad infinitum. And of course, this case, I think along with the Catholic Charities case, I'll check my facts on this, but is driven by Becket Fund, which is one of the many Christian nationalist groups that are pushing this agenda through our courts and our legislatures every day. So this is one of the cases FFRF filed a friend of the court amicus brief in. Our legal fellow Hirsch Joshi said in that brief, parents claiming exposure to history or life skills violates their rights have always lost until now. In other words, this same thing has been tried in the past by, yesterday's anti-civil rights warriors, right? Like all the people that didn't want desegregation or, Black history to be taught in schools, and all of these things that, taught a view of racial equality that people claimed violated their religious rights, or historical telling, teaching about slavery, things that violated the most conservative religious parents' viewpoints. Courts would never give this kind of a hearing to or this kind of a treatment to the free exercise rights of those parents to control public school curriculum or the way that public schools teach kids about acceptance and existence and representation until now.
Yep, things have changed so much. And the bottom line, this is about censorship. It's about religious groups wanting to control what public school students see, hear, what they learn, all of that. If carried forward, this is, as we said, it's going to gut the teaching of evolution, sex education. Imagine the issues that are going to come up there. History, anything deemed offensive to fundamentalist beliefs is going to be, it's going to be a question whether that can still be taught in public schools or not, or how it's going to go. It's
a massive, backlash and regression of our society. It's setting us back to the darker days when civil rights and racial equality and acceptance and inclusivity were not secular values that public schools could or would champion and teach students. It's just going to make our students less equipped to live in a pluralistic society. And that's probably the goal, or part of the goal, right? It's to close off and, put back in the closet these groups that have gained acceptance and equality over the past few decades.
Yeah, so like you said, all three of these rulings, the reason why we're talking about them here at FFRF is that they all, like you said, are an attack on secularism, on a society that doesn't base its decisions based on religion or religious beliefs. All of these cases kind of go against that.
These battles continue. FFRF continues to file lawsuits as we speak, challenging state action that violates the separation of church and state. We continue to argue and advocate in cases and in other forms of advocacy for a like sensible, historically sound interpretation of the free exercise clause and a true rational and like historically tethered meaning of religious liberty as our founders would have intended, which means the fact that the Establishment Clause, the state-church separation, actually exists and is an important First Amendment value, and that it works in concert with the Free Exercise Clause and has to be balanced. And there are other state interests that matter besides the religious rights of Christian individuals. And so that's what we exist to continue to fight for every day. And we continue to do that term after term, even though we watch these cases and follow along with what this ultra-conservative Supreme Court is doing damage to.
Yeah, that was a good summation. I'll just leave it at that.
There's still plenty to protect and to push against, and these cases are just the ones that make their way up to the Supreme Court. But
we'll probably see more next year, unfortunately.
Yep, that's right. Well, that wraps up this week's episode of FFRF's Ask an Atheist. You can also check out Free Thought Radio at ffrf.org/radio or wherever you get your podcasts. Speaking of podcasts, check out the latest episode of We Dissent, the only podcast hosted exclusively by women constitutional lawyers, including me, discussing state-church separation. Listen and subscribe to We Dissent wherever you get podcasts, or check us out online at we-dissent.org.
Finally, if you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. If not, please join us, and we will see you next time on FFRF's Ask an Atheist.